Property 236. As before, T remains in privity of contract with L for the duration of the original lease. In this example, there are no assignments, so we begin by asking which parties have successive property interests. When the possessory rights of T2 end, T will then have control over the property. Thus T2 and T have a privity of estate relationship. Then, when T's rights over the property conclude, the possessory rights will flow back to the landlord, meaning that T and L also have privity of estate. Before moving on, one final wrinkle merits attention. As discussed earlier, when the original tenant subleases or assigns his leasehold, the default rule is that the landlord and the new tenant are not in privity of contract. It is possible, however, to create a privity of contract relationship between the L and T2. Most often this is accomplished by including a clause in the takeover agreement between the original tenant and the new tenant that reads, "New tenant assumes the obligation to perform all of the original tenant's duties under the original lease." If the new tenant takes on this responsibility, the landlord becomes a third-party beneficiary to the agreement and comes into privity of contract with the new tenant. Problems. 1. Landlord leases property to T1 from the 1st of January, 2015 to the 31st of December, 2015. On March 1, T1 sold T2 her remaining interest in the property. On October 1, T2 rented the property to T3 for 2 months. Describe the privity relationships between all of the parties. If T3 stops sending rent payments to landlord, whom can the landlord sue to recover the money? Chapter 8, Leasing Real Property 237. 2. Alger, a landlord, rents a commercial building to Brown for 5 years. 6 months into the lease, Brown subleases his interest to Clancy for 3 years. Clancy then turns around and assigns his interest to Dahl. Describe the privity relationships between all of the parties. If Dahl stops sending rent checks to Alger, whom can Alger sue to recover the money? 3. Picasso, a landlord, rents an apartment to Renoy for 1 year. The lease contains a provision allowing the tenant to renew the leasehold for a second year on the same terms. Renoy assigns his interest in the lease to Srat. Srat then assigns his interest to Turner. What are the privity relationships between the parties? Can Turner exercise the renewal clause in the original lease? C. Castle v. Double Time, Inc., 737 p.2d 900, Oakland 1987, discussing renewal clauses. 4. Landlord leases a unit to T1 for 10 years beginning in 2010. In 2012, T1 transfers all of his right to T2 for a period of 5 years. In 2013, T2 subleases to T3 for 1 year. What are the privity relationships and whom can the landlord sue if T3 stops paying rent? 5. L leases a commercial property to T1 for 10 years beginning in 2010. In 2012, T1 assigns all of her interest to T2. A year later, T2 assigns all of her interest to T3. In 2014, T3 subleases to T4 for a term of 4 years. In the sublease contract, T4 agrees to assume all of the covenants and promises in the original lease between L and T1. In 2015, T4's business fails and she ceases paying rent. What are the privity relationships? Whom can L sue to recover the unpaid rent money? 3. Tenant exit, limiting the right to transfer. Under the traditional common law, leaseholds were freely transferable property interests. Modern courts continue to recognize the alienability of tenancies as a default position, but allow parties to contract around the basic rule. As a result, most leases, including yours, probably, now contain some restriction on a tenant's ability to assign or sublease her property interests. For example, one oft-used lease agreement, which Property 238 can be downloaded for free from the internet, includes the following provision: the Tenant will not assign this lease, or sublet or grant any concession or license to use the property or any part of the property. Any assignment or subletting will be void and will, at the landlord's option, terminate the lease. In most states, courts uphold such bars on transfer as reasonable restraints on alienation. More controversial are clauses that allow sublease or assignment but only with the consent of the landlord. Julian v. Christopher. 575.2d 735, MD 1990. Chazanow, Judge. In 1961, this court decided the case of Jacobs v. Klewens, 169.2d 677, 1961, and held that when a lease contained a silent consent clause prohibiting a tenant from subletting or assigning without the consent of the landlord, landlords had a right to withhold their consent to a subletting or assignment even though the withholding of consent was arbitrary and unreasonable. We now have before us the issue of whether the common law rule applied in Klewens should be changed. In the instant case, the tenants, Douglas Julian and William J. Gilliland, 3, purchased a tavern and restaurant business, as well as rented the business premises from landlord Guy D. Christopher. The lease stated in Clause 10 that the premises, consisting of both the tavern and an upstairs apartment, could not be assigned or sublet without the prior written consent of the landlord. Some time after taking occupancy, the tenants requested the landlord's written permission to sublease the upstairs apartment. The landlord made no inquiry about the proposed sublessee, but wrote to the tenants that he would not agree to a sublease unless the tenants paid additional rent in the amount of $150 per month. When the tenants permitted the sublessee to move in, the landlord filed an action in the District Court of Maryland in Baltimore City requesting repossession of the building because the tenants had sublet the premises without his permission. At the District Court trial, the tenants testified that they specifically inquired about Clause 10, and were told by the landlord that the clause was merely included to prevent them from subletting or assigning to someone who would tear the apartment up. The District Court judge refused to consider this testimony. He stated in his oral opinion that he would remain within the four corners of the lease, and construe the document. Chapter 8, Leasing Real Property 239. Strictly at least as it pertained to Clause 10. Both the District Court and, on appeal, the Circuit Court for Baltimore City found in favor of the landlord. The circuit judge noted, if you don't have the words that consent will not be unreasonably withheld, then the landlord can withhold his consent for a good reason, a bad reason, or no reason at all in the context of a commercial lease, which is what we are dealing with. We granted certiorari to determine whether the Klewens holding should be modified in light of the changes that have occurred since that decision. While we are concerned with the need for stability in the interpretation of leases, we recognize that since the Klewens case was decided in 1961, the foundations for that holding have been substantially eroded. The Klewens opinion cited restatement of Property 410 as authority for its holding. The current restatement, second, of Property 15.2 rejects the Klewens doctrine and now takes the position that a restraint on alienation without the consent of the landlord of the tenant's interest in the leased property is valid, but the landlord's consent to an alienation by the tenant cannot be withheld unreasonably, unless a freely negotiated provision in the lease gives the landlord an absolute right to withhold consent. Another authority cited in Klewens in support of its holding was 2R Powell on real property. The most recent edition of that text now states, thus, if a lease clause prohibited the tenant from transferring his or her interest without the landlord's consent, the landlord could withhold consent arbitrarily. This result was allowed because it was believed that the objectives served by allowing the restraints outweighed the social evils implicit in them, inasmuch as the restraints gave the landlord control over choosing the person who was to be entrusted with the landlord's property and was obligated to perform the lease covenants. It is doubtful that this reasoning retains full validity today. Relationships between landlord and tenant have become more impersonal and housing space, and in many areas, commercial space as well, has become scarce. These changes have had an impact on courts and legislatures in varying degrees. Modern courts almost universally adopt the view that restrictions on the tenant's right to transfer are to be strictly construed. Footnotes omitted. 2 R. Powell on Real Property 248, 1, 1988. Property 240. Finally, in support of its decision in Clewens, this court noted that, although it apparently has not been passed upon in a great number of jurisdictions, the decisions of the courts that have determined the question are in very substantial accord. Clewens 169.2d at 679. This is no longer true. Since Clewens, the trend has been in the opposite direction. The modern trend is to impose a standard of reasonableness on the landlord in withholding consent to a sublease unless the lease expressly states otherwise. Campbell v. Westall, 715p.2d 288, 292, RIs. CT App. 1985. Traditional property rules favor the free and unrestricted right to alienate interests in property. Therefore, absent some specific restriction in the lease, a lessee has the right to freely alienate the leasehold interest by assignment or sublease without obtaining the permission of the lessor. Oskashinsky, American Law of Landlord and Tenant 5:6. 1980, 1 American Law of Property 3.56, 1952. Contractual restrictions on the alienability of leasehold interests are permitted. R. Cunningham, W. Stoebuck, and D. Whitman, The Law of Property 12.40, 1984. Consequently, landlords often insert clauses that restrict the lessee's common law right to freely assign or sublease. ID. Probably the most often used clause is a silent consent clause similar to the provision in the instant case, which provides that the premises may not be assigned or sublet without the written consent of the lessor. In a silent consent clause requiring a landlord's consent to assign or sublease, there is no standard governing the landlord's decision. Courts must insert a standard. The choice is usually between 1, requiring the landlord to act reasonably when withholding consent, or 2, permitting the landlord to act arbitrarily and capriciously in withholding consent. Public policy requires that when a lease gives the landlord the right to withhold consent to a sublease or assignment, the landlord should act reasonably, and the courts ought not to imply a right to act arbitrarily or capriciously. If a landlord is allowed to arbitrarily refuse consent to an assignment or sublease, for what in effect is no reason at all, that would virtually nullify any right to assign or sublease. Because most people act reasonably most of the time, tenants might expect that a landlord's consent to a sublease or assignment would be governed by standards of reasonableness. Most tenants probably would not understand that a clause stating this. Chapter 8, Leasing Real Property 241. Lease may not be assigned or sublet without the landlord's written consent means the same as a clause stating the tenant shall have no right to assign or sublease. Some landlords may have chosen the former wording rather than the latter because it vaguely implies, but does not grant to the tenant, the right to assign or sublet. There are 2 public policy reasons why the law enunciated in Clewens should now be changed. The first is the public policy against restraints on alienation. The second is the public policy which implies a covenant of good faith and fair dealing in every contract. Because there is a public policy against restraints on alienation, if a lease is silent on the subject, a tenant may freely sublease or assign. Restraints on alienation are permitted in leases, but are looked upon with disfavor and are strictly construed. Powell on Real Property, Supra. If a clause in a lease is susceptible of 2 interpretations, public policy favors the interpretation least restrictive of the right to alienate freely, interpreting a silent consent clause so that it only prohibits subleases or assignments when a landlord's refusal to consent is reasonable, would be the interpretation imposing the least restraint on alienation and most in accord with public policy. Since the Clewens decision, this court has recognized that in a lease, as well as in other contracts, there exists an implied covenant that each of the parties thereto will act in good faith and deal fairly with the others. Food Fair v. Blumberg, A.2d 166, 174, 1964. When the lease gives the landlord the right to exercise discretion, the discretion should be exercised in good faith, and in accordance with fair dealing. If the lease does not spell out any standard for withholding consent, then the implied covenant of good faith and fair dealing should imply a reasonableness standard. We are cognizant of the value of the doctrine of stare decisis, and of the need for stability and certainty in the law. However, as we noted in Harrison v. Morn Company, BD of Educ, 456. A.2d 894, 903, 1983, a common law rule may be modified where we find, in light of changed conditions or increased knowledge, that the rule has become unsound in the circumstances of modern life, a vestige of the past, no longer suitable to our people. The Cluan's common law interpretation of the silent consent clause represents such a vestige of the past and should now be changed. Property 242. Reasonableness of withheld consent. In the instant case, we need not expound at length on what constitutes a reasonable refusal to consent to an assignment or sublease. We should, however, point out that obvious examples of reasonable objections could include the financial irresponsibility or instability of the transferee, or the unsuitability or incompatibility of the intended use of the property by the transferee. We also need not expound at length on what would constitute an unreasonable refusal to consent to an assignment or sublease. If the reasons for withholding consent have nothing to do with the intended transferee or the transferee's use of the property, the motivation may be suspect. Where, as alleged in this case, the refusal to consent was solely for the purpose of securing a rent increase, such refusal would be unreasonable unless the new subtenant would necessitate additional expenditures by, or increased economic risk to, the landlord. Prospective effect. The tenants ask us to retroactively overrule Cluans, and hold that in all leases with silent consent clauses, no matter when executed, consent to assign or sublease may not be unreasonably withheld by a landlord. We decline to do so. In the absence of evidence to the contrary, we should assume that parties executing leases when Cluans governed the interpretation of silent consent clauses were aware of Cluans and the implications drawn from the words they used. We should not, and do not, rewrite these contracts. In appropriate cases, courts may in the interest of justice give their decisions only. Prospective effect. Contracts are drafted based on what the law is. To upset such transactions even for the purpose of improving the law could be grossly unfair. For leases with silent consent clauses which were entered into before the mandate in this case, Cluans is applicable, and we assume the parties were aware of the court decisions interpreting a silent consent clause as giving the landlord an unrestricted right to withhold consent. For leases entered into after the mandate in this case, if the lease contains a silent consent clause providing that the tenant must obtain the landlord's consent in order to assign or sublease, such consent may not be unreasonably withheld. If the parties intend to preclude any transfer by assignment or sublease, they may do so by a freely. Chapter 8, Leasing Real Property 243. Negotiated provision in the lease. For example, the clause might provide, consent may be withheld in the sole and absolute subjective discretion of the lessor. The final question is whether the tenants in the instant case, having argued successfully for a change in the law, should receive the benefit of the change. Even though our decision is to have only prospective effect, he tenants in the instant case should get the benefit of the interpretation of the silent consent clause that they so persuasively argued for, unless this interpretation would be unfair to the landlord. We note that the tenants testified they were told that the clause was only to prevent subleasing to someone who would tear the apartment up. Therefore, we will reverse the judgment of the circuit court with instructions to vacate the judgment of the district court and remand for a new trial. At that trial, the landlord will have the burden of establishing that it would be unfair to interpret the silent consent clause in accordance with our decision that a landlord must act reasonably in withholding consent. He may establish that it would be unfair to do so by establishing that when executing the lease he was aware of and relied on the clause's interpretation of the silent consent clause. Notes and questions. 1. Landlords love restrictions. Why are restrictions on transfer so common in both commercial and residential leases? You might want to refer back to the Sprawl Mart example from earlier in the chapter, which makes clear why a landlord and tenant might disagree about who should get the benefit of the remaining term. 2. Status of the Julian rule. The approach taken in Julian, which reads a reasonableness requirement into the lease, is still a minority rule. Roughly 15 states have taken a position similar to Maryland's highest court, including California, Illinois, North Carolina, and Ohio. Although the Julian /minority approach has gained popularity in the last 2 decades, and is considered the modern rule, it's important to note that in most states a landlord may still arbitrarily refuse to consent to any sublease or assignment under a silent consent clause. 3. Contracting around the rule. Imagine a lease that includes the following provision: the tenant shall not sublease or assign any part of their interest in property 244. The property without the landlord's written permission. The landlord reserves the absolute right to deny any request for any and all reasons at his sole and absolute discretion. Under the holding in Julian, would this clause be valid? See Restatement, 2nd, Property 15.2, a restraint on alienation with the consent of the landlord of the tenant's interest in the leased property is valid. But the landlord's consent to an alienation by the tenant cannot be withheld unreasonably, unless a freely negotiated provision in the lease gives the landlord an absolute right to withhold consent. 4. Defining reasonableness. What counts as a reasonable objection to a sublease or assignment request? Courts in Illinois have found that it's proper to consider 1. The sublessee's credit history, 2. The sublessee's capital on hand, 3. Whether the sublessee's business is compatible with landlord's other properties, 4. Whether the sublessee's business will compete with those of the lessor or any other lessee, and 5. The sublessee's expertise and business plan. C. 4. Example, Jack Frost Sales, Inc. v. Harris Trust and Savings Bank, 433 NE2D 941, IL. App. 3D 1982. In most jurisdictions, tenants have the burden to show the sublessee or assignee meets the reasonable commercial standard. 5. The landlord's stance. Is the reasonableness rule fair to landlords? Imagine you're a landlord and your original tenant announces that they're moving out and proffers a sublessee for your approval. If you're not completely satisfied with the new tenant, should you object? If you say no and the tenant either leaves or sues you, how much will that enforcement action cost? 6. Residential v. Commercial. Courts have not imposed the rule articulated in Julian on residential tenants. Why not? Aren't commercial tenants better able to protect themselves and bargain than residential tenants? Consider the following statute from a jurisdiction where residential leases account for a huge proportion of extremely scarce housing stock, New York. As you read it, consider whether and to what extent the statute permits parties to residential leases to contract around its provisions, and whether it is more or less restrictive than the rule of Julian. Chapter 8, Leasing Real Property 245. New York Real Property Law 226b. 1. Unless a greater right to assign is conferred by the lease, a tenant renting a residence may not assign his lease without the written consent of the owner, which consent may be unconditionally withheld without cause provided that the owner shall release the tenant from the lease upon request of the tenant upon 30 days' notice. If the owner unreasonably withholds consent, which release shall be the sole remedy of the tenant. If the owner reasonably withholds consent, there shall be no assignment and the tenant shall not be released from the lease. 2. A tenant renting a residence pursuant to an existing lease in a dwelling having 4 or more residential units shall have the right to sublease his premises subject to the written consent of the landlord in advance of the subletting. Such consent shall not be unreasonably withheld. B. The tenant shall inform the landlord of his intent to sublease by mailing a notice of such intent by certified mail, return receipt requested. Such request shall be accompanied by the following information: I. The term of the sublease. 2. The name of the proposed sublessee. 3. The business and permanent home address of the proposed sublessee. 4. The tenant's reason for subletting. V. The tenant's address for the term of the sublease. 6. The written consent of any co-tenant or guarantor of the lease, and 7. A copy of the proposed sublease, to which a copy of the tenant's lease shall be attached if available, acknowledged by the tenant and proposed subtenant as being a true copy of such sublease. C. Within 10 days after the mailing of such request, the landlord may ask the tenant for additional information as will enable the landlord to determine if rejection of such request shall be unreasonable. Any such request for additional information shall not be unduly burdensome. Within 30 days after the mailing of the request for consent, or of the additional information reasonably asked for by the landlord, whichever is later, the landlord shall send a notice to the tenant of his consent, or, if he does not consent, his reasons therefor. Landlord's failure to send such a notice shall be deemed to be a consent to the proposed subletting. If the landlord consents, the premises may be sublet in accordance with the request, but the tenant thereunder shall nevertheless remain liable for the performance of tenant's obligations under said lease. If the landlord reasonably withholds consent, there shall be no subletting and the tenant shall Property 246 not be released from the lease. If the landlord unreasonably withholds consent, the tenant may sublet in accordance with the request and may recover the costs of the proceeding and attorney's fees if it is found that the owner acted in bad faith by withholding consent. 5. Any sublet or assignment which does not comply with the provisions of this section shall constitute a substantial breach of lease or tenancy. 6. Any provision of a lease or rental agreement purporting to waive a provision of this section is null and void. Problems. 1. Last year, X rented a storefront in a local strip mall and opened a successful coffee shop. The lease is for 10 years and includes the following provision: no assignments or subleases without the landlord's consent. Landlord can only deny consent based on commercially reasonable objections. Recently X was offered her dream job on a coffee plantation in a faraway country. She now wishes to exit her lease. Must the landlord consent to the following assignment? Proposals. A. Alfred plans to open a mattress store. He's a college dropout with no business experience, but his rich father will co-sign the lease and guarantee all payments get made on time. B. Bob, an experienced therapist with good credit, wants to open a marriage counseling practice targeted at same-sex couples. The landlord, however, believes same-sex marriage is immoral and worries that the counseling center will hurt the business of a Christian bookstore in the strip mall. C. Kathy has a well-thought-out plan to open a shooting range. The landlord agrees to the assignment on the condition that Kathy increase the rent payment by $100/month. Kathy refuses. Chapter 8, Leasing Real Property 247. 4. Tenant exit, abandonment and the duty to mitigate. A tenant who needs to exit a lease early and cannot find another party to sublet must seek out other alternatives. For example, a tenant can always ask her landlord to terminate the lease before the term ends. The tenant generally agrees to turn over the property and pay a small fee and, in return, the landlord releases the tenant from all further obligations. This is called a surrender. Alternatively, a tenant may simply pack her things, abandon the premise, and stop making rent payments. This often happens if a tenant cannot work out a surrender agreement or finds herself in desperate financial circumstances. What are the rights and obligations of the parties in this scenario? What happens if a tenant breaks a lease and leaves the Pierre Apartments today? SOMV. Kreidel. 378.2d 767, NJ 1977. Pushman, J. We granted certification in these cases to consider whether a landlord seeking damages from a defaulting tenant is under a duty to mitigate damages by making reasonable efforts to re-let an apartment wrongfully vacated by the tenant. Separate parts of the Appellate Division held that, in accordance with their respective leases, the landlords, Property 248, in both cases could recover rents due under the leases regardless of whether they had attempted to re-let the vacated apartments. Although they were of different minds as to the fairness of this result, both parts agreed that it was dictated by Joyce v. Baumann. 174 693, 1934. We now reverse and hold that a landlord does have an obligation to make a reasonable effort to mitigate damages in such a situation. We therefore overrule Joyce v. Baumann to the extent that it is inconsistent with our decision today. This case was tried on stipulated facts. On the 10th of March 1972, the defendant, James Kreidel, entered into a lease with the plaintiff, Abraham Sommer, owner of the Pierre Apartments in Hackensack, to rent apartment 6L in that building. The term of the lease was from the 1st of May 1972 until the 30th of April 1974, with a rent concession for the first 6 weeks, so that the first month's rent was not due until the 15th of June 1972. 1 week after signing the agreement, Kreidel paid Sommer $690. Half of that sum was used to satisfy the first month's rent. The remainder was paid under the lease provision, requiring a security deposit of $345. Although defendant had expected to begin occupancy around May 1, his plans were changed. He wrote to Sommer on the 19th of May 1972, explaining, "I was to be married on the 3rd of June 1972. Unhappily the engagement was broken, and the wedding plans cancelled. Both parents were to assume responsibility for the rent after our marriage. I was discharged from the U.S. Army in October 1971 and am now a student. I have no funds of my own, and am supported by my stepfather. In view of the above, I cannot take possession of the apartment and am surrendering all rights to it. Never having received a key, I cannot return same to you. I beg your understanding and compassion in releasing me from the lease, and will of course, in consideration thereof, forfeit the 2 months' rent already paid. Please notify me at your earliest convenience." Plaintiff did not answer the letter. Chapter 8, Leasing Real Property 249. Subsequently, a third party went to the apartment house and inquired about renting apartment 6L. Although the parties agreed that she was ready, willing and able to rent the apartment, the person in charge told her that the apartment was not being shown, since it was already rented to Kreidel. In fact, the landlord did not re-enter the apartment or exhibit it to anyone until the 1st of August 1973. At that time it was rented to a new tenant for a term beginning on the 1st of September 1973. The new rental was for $345 per month, with a 6-week concession similar to that granted Kreidel. Prior to reletting the new premises, plaintiff sued Kreidel in August 1972, demanding $7,590, the total amount due for the full 2-year term of the lease. Following a mistrial, plaintiff filed an amended complaint asking for $5,865, the amount due between May 1, 1972 and the 1st of September 1973. The amended complaint included no reduction in the claim to reflect the 6-week concession provided for in the lease or the $690 payment made to plaintiff after signing the agreement. Defendant filed an amended answer to the complaint, alleging that plaintiff breached the contract, failed to mitigate damages, and accepted defendant's surrender of the premises. He also counterclaimed to demand repayment of the $345 paid as a security deposit. The trial judge ruled in favor of defendant. Despite his conclusion that the lease had been drawn to reflect the settled law of this state, he found that justice and fair dealing imposed upon the landlord the duty to attempt to relet the premises and thereby mitigate damages. He also held that plaintiff's failure to make any response to defendant's unequivocal offer of surrender was tantamount to an acceptance, thereby terminating the tenancy and any obligation to pay rent. As a result, he dismissed both the complaint and the counterclaim. The appellate division reversed in a per curiam. Opinion, 153 N.J. Super. 1, 1976, and we granted certification. 2. As the lower courts in both appeals found, the weight of authority in this state supports the rule that a landlord is under no duty to mitigate damages caused by a defaulting tenant. See Joyce v. Bauman, Supra. This rule has been followed in a majority of states, and has been tentatively adopted in the American Law Institute's Restatement of Property. Property 250. Nevertheless, while there is still a split of authority over this question, the trend among recent cases appears to be in favor of a mitigation requirement. The majority rule is based on principles of property law which equate a lease with a transfer of a property interest in the owner's estate. Under this rationale, the lease conveys to a tenant an interest in the property which forecloses any control by the landlord. Thus, it would be anomalous to require the landlord to concern himself with the tenant's abandonment of his own property. Wright v. Bauman, 398 p.2d 119, 120. 21, or 1965. For instance, in Muller v. Beck, Supra, where essentially the same issue was posed, the court clearly treated the lease as governed by property, as opposed to contract, precepts. The court there observed that the tenant had an estate for years, but it was an estate qualified by this right of the landlord to prevent its transfer 110 at 832, and that the tenant has an estate with which the landlord may not interfere. ID at 832. Similarly, in Heckle v. Gries, Supra, the court noted the absolute nature of the tenant's interest in the property while the lease was in effect, stating that when the tenant vacated, no one, in the circumstances, had any right to interfere with the defendant's possession of the premises. 171 or 148, 149. Other cases simply cite the rule announced in Muller v. Beck, Supra, without discussing the underlying rationale. See Joyce v. Bauman, Supra, 174. 693. Yet the distinction between a lease for ordinary residential purposes and an ordinary contract can no longer be considered viable. As Professor Powell observed, evolving social factors have exerted increasing influence on the law of estates for years. 2. Powell on Real Property, 1977 ed. 221, 1, at 180-81. The result has been that the complexities of city life, and the proliferated problems of modern society in general, have created new problems for lessors and lessees, and these have been commonly handled by specific clauses in leases. This growth in the number and detail of specific lease covenants has reintroduced into the law of estates for years a predominantly contractual ingredient. ID at 181. This court has taken the lead in requiring that landlords provide housing services to tenants in accordance with implied duties which are hardly consistent with the property. Chapter 8, Leasing Real Property 251. Notions expressed in Muller v. Beck, Supra, and Heckle v. Gries, Supra. See Brayman v. Overlook Terrace Corporation, 346.2d76, 1975, liability for failure to repair defective apartment door lock, Berzito v. Gambino, 308.2d17, 1973, construing implied warranty of habitability and covenant to pay rent as mutually dependent, Marini v. Ireland, 265.2d 526, 1970, implied covenant to repair, Rest Realty Corporation v. Cooper, 251. A.2d 268, 1969, implied warranty of fitness of premises for leased purpose. In fact, in Rest Realty Corporation v. Cooper, Supra, we specifically noted that the rule which we announced there did not comport with the historical notion of a lease as an estate for years. 251 A.2d 268. And in Marini v. Ireland, Supra, we found that the guidelines employed to construe contracts have been modernly applied to the construction of leases. 265 A.2d at 532. Application of the contract rule requiring mitigation of damages to a residential lease may be justified as a matter of basic fairness. 4. Professor McCormick first commented upon the inequity under the majority rule when he predicted in 1925 that eventually the logic, inescapable according to the standards of a jurisprudence of conceptions which permits the landlord to stand idly by the vacant, abandoned premises and treat them as the property of the tenant and recover full rent, will yield to the more realistic notions of social advantage which in other fields of the law have forbidden a recovery for damages which the plaintiff by reasonable efforts could have avoided. McCormick, The Rights of the Landlord upon Abandonment of the Premises by the Tenant, 23 Mitch. L. Revelation 211, 221-22, 1925. Various courts have adopted this position. The pre-existing rule cannot be predicated upon the possibility that a landlord may lose the opportunity to rent another empty apartment because he must first rent the apartment vacated by the defaulting tenant. Even where the breach occurs in a multi-dwelling building, each apartment may have unique qualities which make it attractive to certain individuals. Significantly, in SOM v. Cridle, there was a specific request to rent the apartment vacated by the defendant. There is no reason to believe that absent this vacancy the landlord could have succeeded in renting a different apartment to this individual. Property 252. We therefore hold that antiquated real property concepts which served as the basis for the pre-existing rule, shall no longer be controlling where there is a claim for damages under a residential lease. Such claims must be governed by more modern notions of fairness and equity. A landlord has a duty to mitigate damages where he seeks to recover rents due from a defaulting tenant. If the landlord has other vacant apartments besides the one which the tenant has abandoned, the landlord's duty to mitigate consists of making reasonable efforts to re-let the apartment. In such cases he must treat the apartment in question as if it was one of his vacant stock. As part of his cause of action, the landlord shall be required to carry the burden of proving that he used reasonable diligence in attempting to re-let the premises. We note that there has been a divergence of opinion concerning the allocation of the burden of proof on this issue. See Annett, Supra, S12 at 577. While generally in contract actions, the breaching party has the burden of proving that damages are capable of mitigation. Here the landlord will be in a better position to demonstrate whether he exercised reasonable diligence in attempting to re-let the premises. 3. The SOM v. Cridle case presents a classic example of the unfairness which occurs when a landlord has no responsibility to minimize damages. SOM waited 15 months and allowed $4,658.50 in damages to accrue before attempting to re-let the apartment. Despite the availability of a tenant who was ready, willing and able to rent the apartment, the landlord needlessly increased the damages by turning her away. While a tenant will not necessarily be excused from his obligations under a lease simply by finding another person who is willing to rent the vacated premises, see, e.g., Regit v. Dempsey and Company, 216 N.E.2D 500 ill. App. 1966, new tenant insisted on leasing the premises under different terms, Edmonds v. Rust and Richardson Drug Company, 77 NE 713, Mass 1906. Landlord need not accept insolvent tenant. Here there has been no showing that the new tenant would not have been suitable. We therefore find that plaintiff could have avoided the damages which eventually accrued, and that the defendant was relieved of his duty to continue paying rent. Ordinarily we would require the tenant to bear the cost of any reasonable expenses incurred by a landlord in attempting to relet the premises. But no such expenses were incurred in this case. Chapter 8, Leasing Real Property 253. In assessing whether the landlord has satisfactorily carried his burden, the trial court shall consider, among other factors, whether the landlord, either personally or through an agency, offered or showed the apartment to any prospective tenants, or advertised it in local newspapers. Additionally, the tenant may attempt to rebut such evidence by showing that he proffered suitable tenants who were rejected. However, there is no standard formula for measuring whether the landlord has utilized satisfactory efforts in attempting to mitigate damages, and each case must be judged upon its own facts. Compare Carpenter v. Wisniewski, 215 N.E.2d 882, Ind. App. 1966, Duty satisfied. Where landlord advertised the premises through a newspaper, placed a sign in the window, and employed a realtor, Regarment Center Capital, Inc., 93 F.2d 667, 115 ALR. 202, 2 Sir 1938, landlord's duty not breached where higher rental was asked since it was known that this was merely a basis for negotiations, Foggia v. Dix, 509 P.2d 412. 414, or 1973, in mitigating damages, landlord need not accept less than fair market value or substantially alter his obligations as established in the pre-existing lease, with Anderson v. Andy Darling Pontiac, Inc., 43 N.W.2d 362, Wis 1950, reasonable diligence not established where newspaper advertisement placed in one issue of local paper by a broker. Consolidated Sun Ray, Inc. v. Oppenstein, 335 F.2d 801, 811, 8 Sir 1964. Dictum, demand for rent which is far greater than the provisions of the lease called for negates landlord's assertion that he acted in good faith in seeking a new tenant. 4.